Title 17. Extra-contractual obligations. Chapter 1. Quasi-contracts. Article 2142. Certain lawful, voluntary and unilateral acts give rise to the juridical relation of quasi-contract to the end that no one shall be unjustly enriched or benefited at the expense of another. Article 2143. The provisions for quasi-contracts in this chapter do not exclude other quasi-contracts which may come within the purview of the preceding article. Section 1. Negotiorum gestio. Article 2144. Whoever voluntarily takes charge of the agency or management of the business or property of another, without any power from the latter, is obliged to continue the same until the termination of the affair and its incidents, or to require the person concerned to substitute him, if the owner is in a position to do so. This juridical relation does not arise in either of these instances. 1. When the property or business is not neglected or abandoned. 2. If in fact the manager has been tacitly authorized by the owner. In the first case, the provisions of Articles 1317, 1403, Number 1, and 1404 regarding unauthorized contracts shall govern. In the second case, the rules on agency and Title X of this book shall be applicable. Article 2145. The officious manager shall perform his duties with all the diligence of a good father of a family, and pay the damages which through his fault or negligence may be suffered by the owner of the property or business under management. The courts may, however, increase or moderate the indemnity according to the circumstances of each case. Article 2146. If the officious manager delegates to another person all or some of his duties, he shall be liable for the acts of the delegate, without prejudice to the direct obligation of the latter toward the owner of the business. The responsibility of two or more officious managers shall be solidary, unless the management was assumed to save the thing or business from imminent danger. Article 2147. The officious manager shall be liable for any fortuitous event. 1. If he undertakes risky operations which the owner was not accustomed to embark upon. 2. If he has preferred his own interest to that of the owner. 3. If he fails to return the property or business after demand by the owner. 4. If he assumed the management in bad faith. Article 2148. Except when the management was assumed to save property or business from imminent danger, the officious manager shall be liable for fortuitous events. 1. If he is manifestly unfit to carry on the management. 2. If by his intervention he prevented a more competent person from taking up the management. Article 2149. The ratification of the management by the owner of the business produces the effect of an express agency, even if the business may not have been successful. Article 2150. Although the officious management may not have been expressly ratified, the owner of the property or business who enjoys the advantages of the same shall be liable for obligations incurred in his interest, and shall reimburse the officious manager for the necessary and useful expenses and for the damages which the latter may have suffered in the performance of his duties. The same obligation shall be incumbent upon him when the management had for its purpose the prevention of an imminent and the manifest loss, although no benefit may have been derived. Article 2151. Even though the owner did not derive any benefit and there has been no imminent and manifest danger to the property or business, the owner is liable as under the first paragraph of the preceding article, provided 1. The officious manager has acted in good faith, and 2. The property or business is intact, ready to be returned to the owner. Article 2152. The officious manager is personally liable for contracts which he has entered into with third persons, even though he acted in the name of the owner, and there shall be no right of action between the owner and third persons. These provisions shall not apply. 1. If the owner has expressly or tacitly ratified the management, or 2. When the contract refers to things pertaining to the owner of the business. Article 2153. The management is extinguished. 1. When the owner repudiates it or puts an end thereto. 2. When the officious manager withdraws from the management, subject to the provisions of Article 2144. 3. By the death, civil interdiction, insanity or insolvency of the owner or the officious manager. Section 2. Solutio indebiti. Article 2154. If something is received when there is no right to demand it, and it was unduly delivered through mistake, the obligation to return it rises. Article 2155. Payment by reason of mistake in the construction or application of a doubtful or difficult question of law may come within the scope of the preceding article. Article 2156. If the payer was in doubt whether the debt was due, he may recover if he proves that it was not due. Article 2157. The responsibility of two or more payees, when there has been payment of what is not due, is solidary. Article 2158. When the property delivered or money paid belongs to a third person, the payee shall comply with the provisions of Article 1984. Article 2159. Whoever in bad faith accepts an undue payment, shall pay legal interest if a sum of money is involved, or shall be liable for fruits received or which should have been received if the thing produces fruits. He shall furthermore be answerable for any loss or impairment of the thing from any cause, and for damages to the person who delivered the thing, until it is recovered. Article 2160. He who in good faith accepts an undue payment of a thing certain and determinate shall only be responsible for the impairment or loss of the same or its accessories and accessions insofar as he has thereby been benefited. If he has alienated it, he shall return the price or assign the action to collect the sum. Article 2161. As regards the reimbursement for improvements and expenses incurred by him who unduly received the thing, the provisions of Title the 5th of Book 2 shall govern. Article 2162. He shall be exempt from the obligation to restore who, believing in good faith that the payment was being made of a legitimate and subsisting claim, destroyed the document, or allowed the action to prescribe, or gave up the pledges, or cancelled the guarantees for his right. He who paid unduly may proceed only against the true debtor or the guarantors with regard to whom the action is still effective. Article 2163. It is presumed that there was a mistake in the payment if something which had never been due or had already been paid was delivered, but he from whom the return is claimed may prove that the delivery was made out of liberality or for any other just cause. Section 3. Other quasi-contracts. Article 2164. When, without the knowledge of the person obliged to give support, it is given by a stranger, the latter shall have a right to claim the same from the former, unless it appears that he gave it out of piety and without intention of being repaid. Article 2165. When funeral expenses are borne by a third person, without the knowledge of those relatives who were obliged to give support to the deceased, said relatives shall reimburse the third person, should the latter claim reimbursement. Article 2166. When the person obliged to support an orphan, or an insane or other indigent person unjustly refuses to give support to the latter, any third person may furnish support to the needy individual, with right of reimbursement from the person obliged to give support. The provisions of this article apply when the father or mother of a child under 18 years of age unjustly refuses to support him. Article 2167. When through an accident or other cause a person is injured or becomes seriously ill, and he is treated or helped while he is not in a condition to give consent to a contract, he shall be liable to pay for the services of the physician or other person aiding him, unless the service has been rendered out of pure generosity. Article 2168. When during a fire, flood, storm, or other calamity, property is saved from destruction by another person without the knowledge of the owner, the latter is bound to pay the former just compensation. Article 2169. When the government, upon the failure of any person to comply with health or safety regulations concerning property, undertakes to do the necessary work, even over his objection, he shall be liable to pay the expenses. Article 2170. When by accident or other fortuitous event, movables separately pertaining to two or more persons are commingled or confused, the rules on co-ownership shall be applicable. Article 2171. The rights and obligations of the finder of lost personal property shall be governed by Articles 719 and 720. Article 2172. The right of every possessor in good faith to reimbursement for necessary and useful expenses is governed by Article 546. Article 2173. When a third person, without the knowledge of the debtor, pays the debt, the rights of the former are governed by Articles 1236 and 1237. Article 2174. When in a small community a majority of the inhabitants of age decide upon a measure for protection against lawlessness, fire, flood, storm or other calamity, anyone who objects to the plan and refuses to contribute to the expenses but is benefited by the project as executed shall be liable to pay his share of said expenses. Article 2175. Any person who is constrained to pay the taxes of another shall be entitled to reimbursement from the latter.